Welcome, and thank you all parties for standing by. All lines will be on a listen-only until the question and answer session of today's conference. At that time, you may press star 1 if you would like to ask a question. Today's conference is being recorded. If you have any objections, you may disconnect. I would now like to turn the conference over to Janice Wingo, International Trade Administration. Thank you. You may begin.
Good morning, and welcome to today's webinar on patent basics. Today, we're very lucky to have with us a licensed patent attorney here from the United States. His name is Richard Jung. Richard Jung is also a licensed attorney in the PRC, and he practices with Kingwood and Mallisons in Shanghai. So his practice is entirely on patents, and he's located in Shanghai, and he's graciously offered to explain China's patent system to us, especially the utility model of practice, which is a little bit different from what happens in the United States. After the presentation by lawyer Jung, there will be a question and answer period for him where the operator will tell you how you can call in and ask some questions. Just wanted to let you know that lawyer Jung received his law degree from Peking University in China, and he received an LLM degree from the University of Washington in Seattle. So he's very well versed in both China and U.S. law and explaining the Chinese system to U.S. clients. So I will let lawyer Jung continue on. Lawyer?
Hello. Yeah, this is Richard Jung. This is my pleasure to have this wonderful opportunity to explain China's patent practice. This time I will focus more on the utility model patent practice because this system is unique in China, very different from the U.S. practice. First of all, I will explain the object of the patent law in China. The patent law is to protect invention and creation. So you can see from the slide, there are 3 types of invention and creation, which means invention, utility model, and design. Invention means a new technical solution proposed for a product, process of the improvement thereof. Generally speaking, invention can cover all technical solutions. The utility model is more focused on the new technical solution proposed for the shape and structure of a product. So only product is the object of the utility model in China. There is no method utility model here in China. So that's a very big difference. But for design, a design patent in China is the same as that of U.S. system, because design patent is only used to protect some new design, not some technical solution. And utility model patent, the name, in terms of name, is similar to the utility patent from the United States, but they are very different because in the United States, there are only 2 types of patents, utility patent and a design patent. So you can somehow you can consider the utility patent equals to invention and the utility model in China. So here for invention and the utility model patents, the keyword is technical. Such patents is used to protect technical solutions. Right now, there are more and more utility model filings in China. I found out this data from the state intellectual property office of China. This official data. You can see that from the very beginning, April 1985 to June of this year, there are more than 4 million utility model filings, and most of them have been granted. And the trend of the filing utility model is growing up quickly, especially in the recent years after the third amendment to China patent law. Next, please. Because this webinar is for the United States audience, so I've also checked the inbound utility model filings. Inbound means some foreign companies file the utility model in China. Utility model system is different from some general practice in U.S. So in the past, not so many foreign companies know this system. Only recent, you can say, recent 4 or 4 years, the amount of the filing from the outside China is growing up very quick. Although the percentage of the utility model filings, the inbound utility model filings is still very, very small, almost just 1%. But the number is going up quickly. The country, Japan, is the biggest country of filing utility model in China. The second position is from the United States. Almost 1,000 utility models filed from U.S. in China last year. So this slide shows the valid utility model patents right now, and the number is huge. Almost, I think it's 12 million. Yeah, you can see the number is very huge. There's some patent litigations in China right now, more and more patent litigations in China right now, and some of them are related to the utility model patents. In China, it's different from the practice of the United States. In China, anyone can go to the PRB, Patent Re-Examination Board, to challenge, to invalidate a patent in China. But for many of such invalidations, usually there will be a patent infringement case ongoing. You can see the number of the invalidations of utility model patents. In recent years, the amount of the patents granted is going, and also for the invalidation related to the utility model patents also is going up. But the percentage is kind of similar. This slide shows the examination period for utility models, because there is no substantial examination for utility model. So the patent office, the utility model examination department of patent office in China only check the formality of the utility model application and some obvious defects. So usually utility model patent can be granted very quick. you can see from this slide, in 2005, usually it will take 11 months. But right now, like last year, it just took 5 months to grant a utility model patent. Right now, I want to explain more about utility model patents. First, the subject matter of utility model. Like I just talked about minutes ago, the product is the only subject matter of utility model, but the technical solution of utility model has to be some object manufactured by industrial method, have some definite shape and structure, occupying a certain space, which means all the process and the object existing naturally are not the subject matter of utility model. And for many technical solutions, such solution can be related to the improvement of both the shape of the product and the manufacturing method. First, under such situation, the improvement will be about both the method and the structure. Such technical solution cannot be the subject matter of utility model because there is method or process improvement. Next. Next, please. Okay. And the shape of the product means the spaceship processed by the product. People can see from the outside. And so, but for the biological shape or naturally formed shape, that's not the shape of product we're talking about now. So if a product just have some improvement or some change of the naturally formed shape, then such change cannot be considered as the improvement of the shape of product. Also, a non-fixed shape formed by means of arrangement or stacking cannot be considered as the shape of product as either. But there are two exceptions. A product may have a certain technical feature of non-fixed shape substance, provided that it is defined by the structure of the feature of the product. Here is an example. It's related to thermometer. Usually, there is some alcohol of non-fixed shape included in the thermometer. So for such situations, it can be protected by utility model patent. And the second exception is if a definite space shape which existing under certain circumstances, such as parachute, it can be protected by the utility model patent. The next category is the structure of the product. The structure of the product refers to the arrangement, organization, of correlation of each part of a product. So, under such situation, a product can be divided into different parts. And these parts can be combined together in somehow and with some improvement. So, in this way, there are some change of the structure of the product. Then it can be such technical solution can be protected by utility model. But for some molecule structure or compound of metallographic structure, they cannot be protected by utility model. This means, from last two slides, I think, cannot be considered as the structure of product that we can see from the outside. So if a technical solution contains not only the features of shape or structure, but also improvement related to the materials per se, such a solution cannot be protected by the utility model either, because there is some improvement related to the materials per se. If you want to file a utility model patent, so there is no improvement to the materials you are using for your product. We talk about a lot of technical solutions. So technical solution means the collection of technical means adopted to solve a technical problem by using the laws of nature, usually embodied by technical features. Patent is not usually related to some specific product. So it's related to the technical solution. And if a solution consists of the shape of a product, of the pattern, of the combination thereof, in the appearance, only appearance of product, that cannot be considered as a technical solution. The next exception is if a solution consists of character, symbol, chart of the combination thereof, only in appearance of the product. So we cannot consider such improvement as a technical improvement, or it's non-functional improvement. So utility model cannot protect such improvement, non-functional improvement. There are three substantive requirements for utility model and invention: novelty, inventiveness, and practical use. For both invention and the utility model, those three requirements apply. First, for novelty, which means a technical solution cannot be an existing technology. There must be some improvement to the existing technology. The second condition about novelty is it's not a patent application which is filed by any unit or individual for any identical invention or utility model before the date of the application for patent rights, which means before your filing, there is no previous patent filing that filed before your filing date. For the second situation, there is no identical invention or utility model is recorded in the patent application document, which are published or announced after the date of application. We call such patent application as the patent application in conflict, because when you file your patent application, such conflict patent application has not been published yet. But after your filing, then such patent application is published after your filing. So there is only novelty requirement for such patent application. because novelty usually means the technical solution is very same or very similar. And for inventiveness, for many patents, it's hard to be challenged successfully by novelty. But for the substantive requirement, usually means the inventiveness, because for novelty means whether those two solutions are same. But for inventiveness, the difference between the technical solutions must be big enough. So compared with the existing technology, the invention should possess prominent substantive features and remarkable advancement. And the utility model should possess substantive features and advancements. It's from the wording of the definition of inventiveness for both the invention and the utility model. It's a little kind of confusing, but in simple word, the standard for inventiveness, but for invention patent application is higher than the inventiveness of utility model. For practical use, it's usually means some technical solutions should have some technical effect and can produce positive results. For the technical solutions from mechanical and electrical field, usually the practical use is not an issue. But for some solution in chemical industry, the practical use can be a problem. The requirement for utility model is simple because the utility model examination department in China Patent Office, that department is not so big. They don't have resources to do the initiative prior search. And so they only can do some preliminary examination, including the formality check and the obvious substantiality check, including the obvious novelty. Obvious novelty usually means when the patent utility model patent examiner, when they see your utility model patent application, they can identify this utility model patent application is too simple, and they are very familiar with such technology because they cannot do the initiative prior search, so they can only judge such obvious substantiality by their knowledge they have. This is a chart to show the difference between utility model and invention and the design patent. You can see the subject matter is a little different because either invention for product and method. Product and method of invention will cover all technology. There is 4 subject matters in the United States, but in China, all technical solutions will be considered as product or method. For utility model, the subject matter will be the shape or structure of product. Design is not a patent to protect some functional improvement. And for the examination procedures for invention, please, back, please. The invention will be published after you file your patent application, and the patent office will publish your invention within 18 months. Then, after 3 years, which means 36 months, the patent office will do the substantial check. The protection term is different. For invention, the patent term is 20 years. Next, please. This is a kind of very unique practice in China, double patenting. The fundamental rule is only one patent can be granted for the same invention. But from the third amendment to China patent law, it changed to the following exception was added to the China patent law. It's where the same applicant applies for a utility model patent and an invention patent with regard to the same innovation on the same day. If the utility model patent required earlier is not terminated yet, and the applicant declares its waiver of the same, then the invention patent may be granted. So, if you want to protect some improvement of your product, you can decide whether you want to file a utility model and the invention at the same time. So, usually, like we just talked about, the utility model can be granted very quick, usually within 1 year, maybe half year. And the invention patent will be granted like 3 years. So if you file your application in this way, then you will have a utility model patent granted earlier. So utility model patent is a patent. Your technology can be protected somehow earlier. And when your invention is granted later, then you give up your utility model, then move to the invention patent. So your technology can be protected for a longer time. Next, please. China is the first to file system, which means if 2 or more applicants apply for a patent for the same invention separately, the patent right will be granted to the first applicant. So the time of filing your patent application in China matters, because if someone else filed earlier than you, then that people will get the patent right. And for the United States, that's the first inventor to file system. So in China, there's no requirement for the patent applicant, no matter the patent applicant is the inventor or not. Next, please. So I want to explain a little bit about the meaning of the definition of patent right. So the patent right is the exclusive right, which means without the patent owner's permission, nobody can do something like the following: manufacture, use, offer to sell, or import the patented product. For the method claim patent. So others cannot use the patented method offer to sell, or import the products that are manufactured by using the patented method. And there's a required agency for foreign companies if such patent applicant doesn't have a regular residence or business site in China. Under such situations, the patent applicant need to hire a patent attorney in China to handle the patent prosecution for them. Except such situations, there's no required agency for patent applicant. So many China companies or Chinese people, they can draft and file their patent application by themselves. But to be honest, the patent system is very complicated. It's better to hire some patent agent to help you. Next, I want to explain a little bit of the examination procedures of the utility model. For utility model, the examination procedure is kind of simple because the patent office received the utility model patent application, then find out the IPC category. Then the case will move from the receiving office to the utility model examination department. Then the patent examiner will do a preliminary examination. If there is some formality defects, then the patent examiner will send a notice of correction of some office action. Office action usually means they have some opinions about the novelty or some obvious substantive defect. So, and if notice of correction of office action is issued from the patent office, then we need to reply within 2 months. Then if the patent examiner is satisfied with the response, then they will grant a utility model patent. Not, then they will reject the utility model application. So then next step is we'll do the registration. There is a big difference between the utility model and the invention practice, because if a utility model patent is not granted, usually they will not be published. And because only after the registration, utility model patent will be published. There's a unique practice for utility model patent in China, because only under the request, the patent office will do the prior art search and give the patent application a search report. Such search report, the prior art search report, can as evidence to show the quality of the utility model patent. Because if a utility model patent owner want to sue some competitor by using the utility model, then the judges of the court will decide whether this utility model patent is good enough, because for patent infringement case, the defendant usually will file an invalidation request before the PRB to challenge that utility model patent. So such a report can show the quality of the utility model to make sure the patent infringement can go on. Otherwise, the IP court can have an opportunity to suspend the patent infringement case. Next, please. As to the utility model patent, actually also for the invention patent applications, the original filing at least have the following documents: a request. That's a request for patent protection, and then also we need to attach the claims. The claims is the heart of our patent application, which show the patent's scope, what's your patent right, and the specification and the drawings thereof. The specification is used to explain, to support the claims. The abstract and the drawings thereof. The abstract is not a legal document. Usually it's used for searching. The power of attorney is required if a patent agency is used. For the utility model patent, the drawings is needed. And there is some major requirements for patent application, including the invention and the utility model. The very important one is sufficient disclosure, because if you want to protect your technology, you have to disclose it to the public. As a change, the patent office will give you a patent right for protection. The written description shall contain a clear and comprehensive description of the invention or utility model, so that to some extent, a skilled people in art can carry it out without spending some extra work. If necessary, pictures shall be attached. For utility model, because utility model is used to protect the shape or structure of a new product, so the pictures is needed. For the written claim, supported by the written description, should contain a clear and concise definition of the scope of the patent protection. The drafting of claims is kind of complicated. This slide shows some drawings of. This is an example of the utility model. Actually, this patent is filed. This is a real case. This case was filed by Philips, a Dutch company, and it's called Garment Steamer. The figure 1 shows the traditional steamer. You can see from the top left part, it's very simple. There's some change on the head of the steamer. For the figure 2 or figure 3, you can see the difference between the compared to the traditional steamer. For your reference, I attached the claims here. And if you want to know the details of the case, you can check it out by the numbers I give you on the top. This is a real case. This is the claims of this independent claim 1. You can see the subject matter of the utility model patent is steamer head for a garment steamer. It comprises a handle, a steam duct, and a frontal contact surface. There's some explanation of these 3 parts. Usually, there's some description between the before the characterized in that. Such part is belonging to the prior art. You can see from the last paragraph, after characterized in that, the steamer had further comprised. This further comprised usually means the improvement of this utility model or this new technology. And because of the time limit, I don't want to explain more about this patent, but you can see that later. And for this slide shows the claim 2 to claim 6. All of them are dependent claim, referring back to claim 1. So there's some, for the features in the claim 1, we call that some very essential features. But for the claim 2 to claim 6, such features are additional features, can improve the quality of the steam head. I want to also explain a little more about the advantage of the utility model system. First, cost, low cost, because there's no substantial examination and less office action, so the cost can be very small. And quick approval. If there's no substantial examination, if the patent is a utility model patent application is dropped following the rules, certain rules, it can be granted very soon, usually within 2 or 8 months. It's great. Right now there is some formality check and the obvious novelty check. But even so, there is a very high possibility to be granted for utility model patent application. If such patent is granted, utility model patent is the patent. You can enforce that patent in China for sure. And for the utility model patent, the damages can be calculated in the same way like an invention patent. If the utility model patent infringement is approved successfully before the court, the biggest damage of the patent infringement case in China in the history is related to the one utility model patent. It's a huge damage. But before the court, before the patent court, the judges usually think the quality of the level of the utility model is lower, so it's hard to suspend a patent litigation. by invalidating a utility model patent. So, but for the standard for utility model is lower compared to invention patent. If the utility model is well drafted, in terms of technology, a utility model patent is harder to be invalidated. And this system is encouraging the small innovation. So the small innovation is also the innovation. So if you have some change to your product, so you can consider to use the utility model system to protect that change, no matter that change is how small. If that change can bring some technical effect, it's worth filing a utility model patent in China. But everything has two sides. Also, there are some disadvantages or risks of utility model in China. First, the patent term is shorter, only 10 years, and the stability is not so good because there is no substantial examination. The patent applicant has no chance to improve the quality of the utility model by answering the office action. And the technical improvement has to be related to the structure or shape of product, and then no method improvement or process improvement included. And there is always a question to file an invention of utility model. But my suggestion is for the important case, you can file an invention and a utility model application at the same time. It's a very helpful practice. Even your invention patent cannot be granted later, at least you have a utility model patent to protect your product. But the subject matter of a utility model is limited. If the utility model patent examiner think your technology is not the subject matter of utility model, it's kind of hard to change that, because from my practice, the patent examiner not only look at the claims, they also look at the description to check, to find out whether the improvement is related to the process or method. Because when we receive such office action, your utility model has not been published. So if there's a problem with your utility model filings, the possible remedy can be to file a new invention application. But the standard of the inventiveness is higher. Next, please. The previous part is related to the patent prosecution practice. Next, I want to talk about the administrative enforcement of patent in China. Sorry, there's a typo. In China. And this a very, very unique practice in China, because usually if a patentee wants to enforce the patent rights, they can only go to the court to sue the potential infringer. But in China, there is an alternative. It's administrative enforcement of patent right. There's some legal basis for for such enforcement. Usually, there is a department called Patent Administration Department, PAD, in all provinces in China, almost all big cities in China. The city-level administration are most commonly found, especially in some south province like Guangdong. Guangdong, the Guangdong province has many manufacturers. Such administration can be considered as the intellectual property office and the science and the technology offices. Usually, those two offices will handle the administrative enforcement of patent in China. This is administrative procedure, so which means such parties need to think about the territorial and the level. So any PAD only have the authority to determine the patent infringement or patent counterfeiting dispute within their territorial, because different provinces or different cities have the different territorial. Usually, the patent owner can only file such request before the PAD where the infringer is located or the infringing act occurs. And you may know there is for some provinces, some cities, there's some local protection. It can be hard to enforce your patent rights before the local patent office in this way. So maybe it's better to move your case before some patent office, intellectual property office, where the infringing act occurs. For provincial level PAD, we only handle some big cases. For the city level PADs, they have more opportunity to handle the patent infringing case or patent counterfeiting cases. This is a chart to show the patent administrative enforcement procedure. Different province or different city, they can set up their own procedure. This procedure is kind of normal, but there can be a little difference from province to province, from city to city. But usually, the procedure is similar. The type of the cases, the first is patent infringement. Patent infringement and such situation is similar like the patent infringement case before the court proceeding. And recently, the China Patent Office, the National Patent Office, issued proposed a draft guideline for the patent infringement to decide how to decide the patent infringement. please. The second type is patent counterfeiting. Counterfeiting is easier to identify, but for the patent infringement case, it's much harder because usually the patent for invention patent and the utility model patent, they are related to the technology. It's hard to find out the relationship between the patent and the product. But for patent counterfeiting, it's much easier because it's usually related to the registration number, the patent number, or some on the product or use it in the advertisement, or some use of a patent registration number in contract, or forging or tampering with the patent certificate. And the PAD also have a responsibility to mediate certain type of patent case if the parties want, both parties want. Mediation is a normal practice in China, even for the patent court or PAD. They can mediate the patent dispute all the time. So the range of the mediation can cover the patent infringement, patent applicant, and the patent application and ownership dispute, the qualification of inventors, the inventorship dispute, or the compensation for inventors. From the last amendment to China patent law, it's a must to give the compensation to the inventor. And the claims for the pre-grant compensation in relation to use by third party after patent application has been published. But in practice, its patent mediation is related to the patent infringement case. If you want to enforce your patent rights in China, you can consider the two ways, administrative or judicial proceedings. There's some difference between them. The advantages of administrative proceeding is efficiency. It's very quick. You can bring some evidence to the PAD to show the infringement, then the PAD can go ahead to find out whether it's true. And the lower cost, compared to the patent court proceeding, the cost is much lower. And easily enforceable orders, PAD, they have a team to enforce the patent right in an administrative way. So they are more familiar with the local market, so it's easier to enforce the orders. And compared to the court proceeding, the procedure is simple. And there's one thing I want to emphasize: obtaining evidence. Obtaining evidence, because there is no discovery in China. You have to find out the infringing product from the open market. But if you file a court proceeding, you can also file an administrative request before the PAD. Then the PAD have a right to to read and to catch some evidence to show the infringement. You can use such evidence before the patent court. So the effect of the such administrative proceeding is very helpful. It's similar. It's not similar. It can be used as a kind of discovery proceeding. Also, there are some disadvantages of the administrative proceedings. One thing is the remedy. Remedy is not is discretionary, and there's no damages. If you want to get some damages, the patentee has to go to the court, and the PAD can put some fines to the infringer, but usually the amount is not so big. And the deterrent is lower, and less penalty because if even the PAD has decided whether there is a patent infringement, either party can disagree with that order and go to the court to have a judicial review of the decision of the PAD. A limited coverage, because no matter the provincial PAD or some city level PAD, the decision of the PAD can only cover their territory. So the coverage is limited. Let's move to the Q&A section. Any questions?
Yes, thank you, Lawyer Zhang. Operator, can you tell us how the listeners can ask a question?
Thank you. At this time, we will begin the question and answer session. If you would like to ask a question, please press *1 on your touch-tone phone. Please unmute your phone and record your name clearly at the prompt. Once again, please press *1 if you would like to ask a question.
Anybody who is listening to the audio recording of this presentation, I wanted to mention that Lawyer Richard Zhang is willing to entertain questions via email. You can see his email address is printed here on the last screen, but it is also, you may also just type it in as ZHENGLIZHU@cn.kwm.com. So Zhang Liju at cn.kwm.com. So kingwoodandmalison.com.
Thank you. And at this time, I'm showing no questions.
Lawyer Zhang, I do have a question.
Please.
The question that comes from U.S. companies, and they ask, how come Chinese companies file for utility model of my invention? It happens often in China. They complain about it, but they don't see the same problem in Germany, where there is also a utility model system, and also there is no substantive examination. So why is it happening in China but not happening in Germany?
Before the third amendment to China's patent law, there's no prior use as the prior use in other public use cannot be a reason to challenge the novelty of the utility model or invention. So, which means, in the past, if invention is used in some country like U.S. or Germany, but it's not published, that invention can be filed in China as a patent application. It's legal in the past. But right now, the public use and the publication both can be used to challenge China's patent. So, for the situation you mentioned, if it's still happening right now, I suggest that U.S. company to challenge the validity of that Chinese patent. If that China's patent is same as that invention in the United States, there should be a very high possibility to invalidate that China's patent successfully. You can see the amount of the patent applications in China right now is huge. So right now there are many discussions about the quality of the patent applications in China, especially related to the utility model, because there is no substantial examination for utility models. But if there is some improvement or change to that U.S. company's invention, and any companies can file a new applications to protect that improvement.
Okay, I understand that. Let's pretend that I'm a U.S. company and I come to you with my invention.
Yeah.
What is your recommendation for me? Do you recommend that I file for both a utility model and an invention patent in China?
Yes. Usually for some type of innovations, I think it's a smart way to file both an invention and a utility model at the beginning. But there's some procedural requirement for such practice. If you file an application in United States or and other countries, you have to file the invention and the utility model at the same date from the same patent applicant for the same innovation within 12 months from the first filing. 12 months, that's a deadline on the basis of the Paris Convention. You cannot file both the invention and the utility model on the basis of a PCT application, because that's too late. PCT will take like 30 months to enter China's national phase. And if the innovation is related to the method claim, both the method and the product improvement, for such improvement, you cannot file a utility model in China right now. But I want to talk about this with more details. If some technical solution is related to the shape or structure of product, and also can relate to some process, only if that process or method is traditional, is old, that's an old method, or old process, or some traditional materials, then that's okay for utility model. You just need to include the name of the older method or older process or older materials in the claim of the utility model patent. So we need to show to the patent examiner the improvement of the technology is only related to the shape or structure of our product.
Richard, what would you say to a company who says that it's very costly to file both a utility model and an invention patent in China? What is your response?
Pardon me?
If it's very expensive to file both, why should they file both?
Oh.
Can you justify the costs of filing both invention patents? I mean, because this is a business, so they have to think about the money. So is it worthwhile to file both invention patents and utility model from a cost perspective?
Yeah, understand. Thank you. And it's wise because the cost is a little higher, but not so much. The procedure of the examination prosecution for invention is complicated. It's costly. But for the utility model, the official fee is small. I think just something like 1,000 RMB, little more than, I think around $200 US. That's the official fee. And for the attorney fees, as to the attorney fee, because the patent applicant file both the invention and the utility model at the same time. Usually, from our practice, we don't charge the extra attorney fees for the utility model if you file both at the same time. We only charge something like a docketing fee, cheap, very cheap. There's no attorney fees for utility model. So the cost can be a little higher, but not so much. And
so a lot of the cost, isn't that associated with the translation of the invention patent? I mean, that's one of the reasons why filing an invention patent in China is expensive, is to do the technical translation.
Yes, I agree.
But you don't need...
Translation can be a big issue for the inbound patent applications. But if you file the invention and the utility model at the same time, so for you already have the Chinese translation for the invention patent application. You just need to use that same translation for the utility model patent application. So, which means there is no extra translation fee for the utility model patent.
So wow, you can get maybe an extra 2.5 years of coverage via your utility model with very little cost, maybe very little cost, like under $1,000 extra cost.
Yeah, something like that. In addition to the attorney fee, the official fee is so low, and so the total cost may be just $300 or $400 US more. But you can protect your patent from half year after your filing in China, and the utility model can make sure you will have a patent right in China, no matter that invention patent is granted or not. And that protection can be at least 2 years longer. I think that's worth to file both the invention and the utility model in China.
Okay, so we would recommend that the U.S. companies have their patent attorney in the United States speak with a patent attorney in China and discuss it thoroughly and then make a recommendation for the U.S. company. But that's something for the U.S. patent attorneys to consider when they're advising their clients here in the U.S.
Yeah, and I met a U.S. client some months ago. Yeah, and when I talk about that utility model system, I believe they like this system very much.
Operator, are there any other questions?
I'm showing no questions at this time.
Well, Richard, we've gone over an hour, but it's a very great subject, and we thank you very, very much for your time. Anybody who's listening at home, Lawyer Jung, Richard Jung at King & Wood Mallison, has said that he'd be willing to take questions. Just email him. His email is zhenglizu@cn.kwm.com. And he'd be happy to take your questions and answer them. And I just really want to thank, my classmate Laura Jones for speaking with us today, because he's, like I said, he's admitted as a patent agent here in the United States and also as attorney in China, so he has a unique perspective to bring to this issue. And we thank you again, Lawyer Jones.
Thank you for having me.
Thank you. This does conclude today's conference. You may disconnect your lines at this time. Thank you for joining.